Good afternoon. Welcome back, everybody. We'll be picking up with our 1:30 agenda item on protection orders. Okay. And we got some good information provided by LSO. I trust everyone's had an opportunity to look through that. And we'll move on with 25 LSO working draft .04 on 121. 121.
Mr. Chairman, Katie Adams, LSO. So this is the protection order amendments bill based on the changes that the judicial branch requested at the last meeting. And so I'll just start walking through those changes starting on page 2. So you'll recall that the protection order statutes, they're found in 2 different places in statute. So we have Title 7 for the stalking and sexual assault protection orders, and then Title 35 for the domestic violence protection orders. And you're going to see some parallel types of amendments in this bill for both types of orders. But starting on page 2, line 6, the definition of court in 73506 is amended to include some additional locations. So it would mean the circuit court in the county where an alleged victim of stalking or sexual assault resides or is found, where the alleged perpetrator of the stalking or sexual assault resides or is found, or where an act of stalking or sexual assault occurred. Moving on to section 73507, there's a little cleanup amendment. Moving on to page 3, we get into the provision regarding the appointment of an attorney. So currently, law provides that if the petition is not filed by the district attorney, the court may appoint an attorney to represent an indigent petitioner. And that language is stricken and it's replaced by the new language, which states that if the victim is under the age of 18, then the court may appoint the district attorney to represent the victim in the action. Moving on to section 73508, this is about when the court is required to hold a hearing. So it's currently within 72 hours, and we're striking that in both places and changing it to 10 days. So upon the filing of a petition for an order of protection, the court must schedule a hearing on the petition to be conducted within 10 days after the filing of the petition. And then also the failure to hold or complete the hearing within 10 days would not affect the validity of the hearing or the order. Moving on to page 4, there's a staff comment that notes that the committee may wish to consider whether to amend the requirement that service be made upon each party at least 24 hours before the hearing, because the hearing would now be required to be held within 10 days after the filing of the petition instead of 72 hours. And there's a note there that the domestic violence protection order doesn't include any requirement regarding when service has to be made relative to the hearing date. Moving on to 73510, this is about notice and service of the order. So an order that's granted pursuant to 73509 needs to be filed with the clerk of court, and a copy must be sent to the clerk or by the clerk to the county sheriff, who must, after service, notify the local law enforcement agency within the county in which the petitioner resides. The order shall be personally served upon the respondent unless the respondent or the respondent's attorney was present in person or by remote means at the time the order was granted. And some of this is changes to parallel some of what Title 35 provides regarding domestic violence protection orders. Moving on to subsection B, we're breaking this out to deal with some separate concepts in different paragraphs. Paragraph B1 talks about extensions of an order. We're really modifying, terminating, or extending the order. And we're going to add in new language that says that any extension of an order of protection under this paragraph shall be served upon the respondent by mailing the order to the last known address of the respondent on file with the clerk of court, and that shall constitute valid notice of the extension. Paragraph 2, there's just a cleanup amendment. And then starting on page 6, we have the amendments to Title 35, which is the Domestic Violence Protection Act. And so you'll see that the definition of court is being amended to be fairly similar to, or almost identical to, the definition that would be in Title 7 to make those parallel. Section 3521-103 is being amended to make this provision regarding who can file a petition more parallel to what's in Title VII. So it would provide that the following persons may petition the court under this act by filing a petition with the circuit court clerk. So that would include the victim. If the victim consents, the district attorney on behalf of the victim, or any person with legal authority to act on behalf of the victim. If the victim is a minor, a vulnerable adult as defined in 3520-102. And moving on to page 8, or any other adult who, because of age, disability, health, or inaccessibility, cannot file the petition. Subsection E currently provides that the court may appoint an attorney to assist and advise the petitioner, or the petitioner may hire an attorney or file pro se. That's being amended to contain a similar provision that if the victim is under the age of 18, the court may appoint the district attorney to represent the victim in the action. The staff comment on page 8 notes that the committee may wish to consider adding the sentence there stating that nothing in this subsection shall prevent the victim from hiring an attorney or filing a petition pro se. That would just parallel with the language that's in Title VII. In addition, the committee may wish to consider whether to amend subsection H, which talks about reasonable attorney's fees. If it were a situation where the district attorney is being appointed, there might be a question about whether or not those fees are recoverable. Section 3521-104 is amended to address when the hearing must be held and to include a similar provision regarding 10 days. So the court would be required to hold a hearing on the petition within 10 days after granting a temporary protection order. And then if an ex parte order is not granted, there's a similar requirement regarding 10 days after the filing of the petition. Moving on to page 10, section 3521-106, there's a cleanup amendment at the beginning of subsection A. And then to parallel what's in Title VII, there's a requirement that the order shall be served upon the respondent unless the respondent or the respondent's attorney was present in person or by remote means at the time the order was granted. And then subsection B contains similar amendments regarding extension of an order of protection and how that's served. Moving on to page 12, this is the applicability section, and it provides that the act shall apply to petitions for stalking, sexual assault, and domestic violence protection orders that are filed on and after July 1st, 2025. The staff comment there notes that the committee may wish to consider specifying whether this act applies to requests to extend a protection order that's filed on and after July 1st, 2025, even though the petition may have been filed before the effective date. And the effective date would be July 1st, 2025. And with that, I would stand for any questions.
Thank you very much, Katie. Representative Shostak.
Thank you, Mr. Chairman. I just have a question. I'm not sure I have a position on what the right answer is here, but in a couple of places, both on page 5, lines 14 to 18, the same mirror provision for Title 35 appears on page 11, lines 4 to 8. When there's an extension of an order of protection, it looks like you're creating a mailbox rule so that service is complete upon depositing it in the mail. And why was that? Do we do that as opposed to requiring actual notice? Because it seems like there's an extension. The defendant might not know about the extension until he receives the mail. So there's a little gap there between service and when he's notified, has received actual notice. What is the rationale for having the mailbox rule there?
Ms. Adams.
Mr. Chairman, Representative Chestik, I would probably defer to the judicial branch to answer that question on why they wanted that language in there.
We're hoping Ms. Butler has the answer.
Mr. Chairman, members of the committee, good afternoon. I've seen you before. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. Representative Chestik, Mr. Chair, through you, the answer to that question is just because it is incredibly difficult to serve respondents after a period of time when that, if you have a 3-year protection order in place and the victim or the petitioner is asking for an extension of that, the sheriff often has a really hard time locating the respondent in those cases. And so essentially, the extension could never get served. And so what the respondent's responsibility when that order of protection is issued is they have a responsibility to update their address with the court. And that is the responsibility of the respondent. And so this is a mechanism to allow for service in a manner that keeps the respondent accountable to the court to update their address over time, just in case that protection order gets extended.
Follow up? Good. Any other questions for Ms. Adams on the bill draft? Seeing none, we'll turn now to Ms. Butler to take it from here. Do you have anything more to add to this request?
Mr. Chairman, I do not.
Is there anyone else in the room wishing to testify on this bill draft? Anybody on Zoom wishing to testify on 121? With that, we'll close public comment. Committee, what's your pleasure on 121?
Move the bill.
Moved by co-chairman, second by Senator Cooper. Discussion on the bill draft. Mr. Co-chairman.
Mr. Chairman, thank you. It's hard to remember everything that we run across during an interim, or, you know, we have so many meetings and things kind of run together. I'm not completely certain the genesis of this bill, but in general, I have for a long time felt like we need to do everything we can for this section of statutes. And I've actually brought legislation, and with your help, committee, we have passed some things that I think have helped on this front. I'm not of the legal profession, but I've for a long time felt like we were deficient in some of these stalking and domestic violence statutes. So I, for one, appreciate this draft. Thank you.
Other comment? Senator Cooper.
Maybe. So for the purpose of this bill, is there any difference between a district attorney and a county attorney?
Doesn't matter. I think the generic reference, right, Mr. Fuller, if we call everything, every prosecutor is referred to as a district attorney.
Yeah, Mr. Chairman, in Title 8, we define district attorney to include county and prosecuting attorney, unless the context, clearly shows otherwise.
Very good. Can I answer your question, Senator? Representative Provenza?
Thank you, Mr. Chairman. On page 3, the changes on lines 2 through 8, it looks like before that you didn't have to be under the age of 18 to potentially get representation, and now you do. And I'm just curious, it looks like we've got someone creeping up here to answer my question. So I'll just defer to her.
Ms. Butler, you want to address the 18-year-old issue on page 3?
Mr. Chairman, Representative Provenza, the reason for that is historically there has been a statutory reference in the protection order statutes that allows the court to appoint an attorney, any attorney, to represent the petitioner in those cases. What we have found is we don't have a mechanism for that within the judicial branch. And so what happens is there's it creates an expectation that the court will appoint an attorney in these cases, and we don't have, we don't have a pot of funds to pay these attorneys, and so that was a way to limit kind of that expectation of who could be appointed and in what circumstances, since we don't have that mechanism currently to compensate attorneys to do that work.
Follow up?
Thank you for that. How complicated is the process? Is this something that people can do? Do we need to, maybe, I think it makes sense to limit it, but then do we need to think of another mechanism in future legislation that is going to be helpful to victims?
Ms. Butler?
Mr. Chairman, Representative Provenza, so we do have pro se forms, and those are created in collaboration with the AG's office. So Ms. Chambers is here as well, so she can speak to some of this. But there are victims advocates offices all over the state. And so if a petitioner, needs assistance with getting a protection order filed, often they will go to the victims advocates office for that assistance.
Representative Oakley.
Thank you, Mr. Chairman. And Ms. Butler, if you know, so was a good answer for, for getting rid of that line, but then what's the rationale behind appointing a county attorney or the DA to represent minors? They're different concepts, and so we've taken out one and added this one. Do you know why we're doing that?
Butler.
Mr. Chairman, I'm going to phone a friend.
Judge Christensen, front and center. Thank you, sir.
Okay, thank you. Mr. Chairman and members of the committee, Brian Christensen, Circuit Court Judge in Turner County, Representative Oakley. We have had cases where there is a criminal prosecution pending and the victim's parents want a protection order, they're unrepresented, and the defense shows up with their attorney and would have the chance to examine without legal representation a minor on a child sexual assault case. So when we try to refer those to go talk to the district attorney's office. If they want to go forward, we can't tell them they can't go forward. But in that situation, we can say, go talk to the district or county attorney, and in most cases, they will withdraw that petition because there's an active prosecution going on, and they don't want their victims to be testifying in a civil hearing unrepresented. That's one of the reasons. Another reasons you can get into split custody of parents, and one parent wants to bring an allegation against another based upon a child may or may not have said something, but it's been being forced by one parent or brought where the child is not necessarily wanting to testify, and against the other parent, and there needs to be some representation of that child in those cases.
Mr. Co-Chairman.
So, thank you, Mr. Chairman. And my apologies to Representative Oakley. I probably didn't hear the question, and maybe the part of the answer was already given to this, but let's go over this again if so, and I'm sorry. Judge, so this new language, I'm curious as to why we single out district attorney. The previous language said that an attorney could be appointed. Why the district attorney, knowing the dockets and the everything, plus just the fact that there are other attorneys out there? Can you speak to that for me?
Mr. Co-Chairman, yes, most of these cases brought are based upon what would be considered a criminal act against a child, and that child does not have legal representation in that civil matter in the protection order, and there are cases being reviewed by the district or county attorney's office. And so that's...
So that 18-year-old barrier, that's the trigger there.
Yes.
Gotcha, okay.
If you're an adult, you can make those decisions on yourself. If you're 16 and a potential victim of a sexual assault, and mom has brought you in, and there's the perpetrator with their criminal defense attorney, that's what this was trying to address.
Further questions? Representative Craigo.
Thank you, Mr. Chairman. So Judge, I'm having the same struggle that Representative Oakley is, and it's fairly narrow. Before it was broad, and in the old days, that other provision worked because your local district judge just called you up and said, you're gonna represent this person, and you did it pro bono. Because that happened, and it still happens in some of the smaller communities, and maybe yours too. I'm struggling with that because you could have a 19-year-old that's not any more able to make that decision than a 17-year-old when we're dealing with that particular circumstance that you're describing right now. And so the narrowness of that's hard for me to, and I'm not sure there's a better answer. I'm just wondering if you would have any other ideas of how we could broaden that a little bit without opening the floodgates.
Mr. Chairman, Representative Crago, yes, and we do, if it appears to be a tenuous situation, we will strongly recommend that they talk to Legal Aid, the Protection Coalition, or get a referral to those agencies when they're an adult. So we do that. That's another mechanism we use. But to have a judge calling from a list of the attorneys and it's going to end up being the same attorneys every time, and we don't have a mechanism to pay them, is what this is trying to address on non-represented petitioners.
Representative Oakley.
Thank you, Mr. Chairman. So if we opened it up, I don't like it. And I'm trying to figure out, because I hear what you're saying, it's not, I understand that, but then just changing it to the district attorney and only the district attorney, and only for minors, do you think, what if it said may appoint an attorney that also included the district attorney, so that we don't make it this narrow as far as the only possibility being the county attorney or the district attorney here? I'm just trying to get your thoughts on it. I know what you're saying, but I don't like this switch either.
Yeah, Mr. Chairman, Representative Oakley, you can broaden that out. I'm just letting you know the practical application in almost all counties, that they don't have an attorney pool to draw from to represent pro bono in protection orders.
Representative Crago.
Thank you, Mr. Chairman. So I just follow up to that. If we're dealing with a sexual assault case, for example, what is the harm in saying any victim, the county attorney could, we're doing that in a juvenile case. What's the difference? Why are we limiting to under 18 only? I guess give us the rationale for that so we all understand where we're going with this.
Mr. Chairman, Representative Crago, I think the argument was, or where was the delineation line, is an adult has the ability to make their own decisions. If they want to go forward or wait till the prosecution's over, resulting in conviction, then it's easier to get the protection order, or go forward knowing that you might be putting yourself at risk. We still encourage them to go talk to the district attorney's office or an attorney or legal aid, or like I say, the Protection Coalition, and also taking into account, I don't really have a problem with that. The district attorneys and county attorneys might.
I'm sure they will. Thank you, Mr. Chairman. So I guess then what I'm, just for education for the rest of us as well, is that as we're going through this process, once charges are filed, likely there's going to be terms and conditions of bond, which is going to apply that. So we don't need the civil side of this. And so this is assuming that it's either pre-charge or it's in that investigation stage where we haven't filed charges yet. And we're asking you as the sitting circuit court judge to make a call right then and there.
Right. And that's it, Representative Crago, Chair, that's it. The judges are very hinky about giving advice from the bench about, you need to go talk to somebody else before we go forward on this, though we try to fashion that in that situation. But that's it, because that's exactly what we're talking about. They need somebody to advise them, and you might want to wait till you get the outcome on the criminal charge before you bring this, because you already have a bond condition that says no contact. So I can't say from the bench, you have no contact, therefore we're not going forward with your protection order.
Follow up.
So this, then, I'm just thinking of this as we're going along, because then my next question is are we violating other statutes by appointing a county attorney to represent in a civil case that's, because the county attorneys have their own list of who they can represent, what they can represent. Are we saying then we're acting on behalf of the state as the county attorney, and we're representing someone technically in a civil matter before they become a victim? I mean, they might be an alleged victim, but until there's charges filed, do we run afoul of that issue? I only know this because I brought a bill my first session and was soundly defeated, and I tried to get it so county attorneys could have a wider range of services provided, i.e. special districts, and we lost. And the Attorney General had issued an opinion saying we could not represent them. And so we dug into that. I'm just curious, because that might start running us afoul of that particular statute, and maybe we have to look at that too.
Judge Christensen.
Chairman, Representative Crago, we pulled that out because it's already in there in some of the subsections in this, as well as the county and district attorneys are representing in juvenile civil matters as well.
Okay. No further questions. Thank you much. Anyone else wishing to testify on Zoom? Anybody else in the room wishing to testify? I'm going to close public comment. Committee, what's your preference? Do we have a motion? Representative Cheswick moves, second by the co-chairman. Discussion or amendments? Representative Oakley.
Thank you, Mr. Chairman. I'm not sure, and my fault, I don't have enough of a grasp on the entire thing to know whether I support it, but I don't like what we've got going on here with appointing the district attorney. So the motion would be, I'm still fine if the court may appoint, it's a may, but I'm just dumping this on the county attorneys and the district attorneys I don't agree with, so I would move to strike the word district. The court may appoint, well, the district, and put on, the court may appoint an attorney to represent an underage person, that's fine, but I don't think that should be on the county attorneys and district attorneys. Page 3, line 6. Strike the district and replace it with un.
Mr. Chairman, I think it would also be page 8, line 12.
Representative Harrelson.
Thank you, Mr. Chairman. That still doesn't fully address the 18 issue, where it kind of narrows it down into just, so if you have that 19 or 20-year-old that is still very much at risk, very much in that position. I don't know, just, I know, might be a different amendment, but it's still in the same area. We need to address that and talk about that.
Bringer the amendment, or second? Representative Provenza.
Thank you, Mr. Chairman. I don't disagree with that. I think that might be another amendment, because I don't know if folks feel that way about both those items, so.
So we'll deal with the attorney question by itself first. Any further comment or question on replacing district attorney with an attorney? Seeing none, all in favor of that amendment, say aye.
Aye.
Those opposed, no. That amendment carries. Further amendments, Representative Oakley.
I almost said, Your Honor, we start doing this. Mr. Chairman, not an amendment, I guess, just, is it all right for me to discuss? I guess, I don't know what the answer is, Representative Harrelson, but I think as explained by the judge, I mean, these are civil matters, so generally they're not something that the taxpayer's just gonna pay for your lawyer. So I think the idea being, you can either go at pro se or you can hire a lawyer, but so keeping it this narrow is like, okay, we will make sure that underage person isn't, isn't unrepresented if they don't have the means, the asset, or the sophistication, but we're not going to open it up that the government's going to supply your civil attorney for everyone. That is, I think, the thought or the discussion.
Representative Provenza.
Thank you, Mr. Chairman. I mean, I think if we open it up, the court still has the discretion. And so my hope would be that it would match kind of what's happening now. I mean, we heard Representative Crago say sometimes he gets told to go do stuff like this. And so I think some district judges or some judges are going to be able to say, I've got these people that can do it. Some places, unfortunately, I think we're going to find won't have any ability to. But if we open it up for some of these more difficult cases, then I think judges then have the discretion to say, I think we need to move on or allow for more help on this, but open for
Mr.
correction.
Co-Chairman.
So, Mr. Chairman, why would we not just strike the language, if the victim is under the age of 18, comma, and that sentence just becomes the court may appoint an attorney to represent the victim?
That's what I
I
would
don't see why
suggest.
we specify under 18. In my professional life prior to serving here, there were cases in which somebody might be 19, but usually it was a she, and she was, for the first time in a town of over several thousand people, and not capable of navigating the court system, for example. So I would move that we strike that language. The court may appoint an attorney.
So we have a motion for an amendment. Do we have a second? Second by Provenza. Discussion on that, Representative Oakland.
Thank you, Mr. Chairman. And to the co-chairman, I mean, that I guess that's the discussion we're having, but I would still go back to that I will be a no vote on this. These are civil proceedings. As it is, we have the entire public defender office for the criminal stuff, and it's extremely expensive. So this is us saying that these civil cases would now, and I know there's a may, but I still am like, that's what legal aid and these other things are for. It's not for the court system to do, to be, that, in my opinion. I think, and that's kind of what we're getting rid of, I think, with the other line, but I think that opens it up. I think that's too broad. These are civil proceedings. I think they can, if they're indigent or something, they can get an attorney via another program, rather than us putting it into statute here and requiring the court to get involved in that. That's kind of where I land on it. So I'd be a no on your amendment.
Mr. Co-Chairman.
You know, I respect that a great deal, appreciate it. I just would push back mildly to the fact that I think what we do to victims in situations like this sometimes is pretty egregious. And I think giving the court an opportunity, to address certain kinds of cases would be appropriate. So I don't see that this language would harm. I think I totally get it. There's all these victim services, and I've helped to point young victims in that direction before. But it's a tough thing to navigate, and it's a tough situation that they're coming out of. There may be a case sometime somewhere where the judge wants to go, you know what, I'm going to give Representative Oakley a call and see if she can't step in and help here. I just don't see that that language harms anything.
Further, Representative Harold.
Thank you, Mr. Chairman. So if we remove that, we kind of go back to what the original language said. And I think that narrowing it isn't bad, because we also don't want it to be a free-for-all, obviously. And I don't know, so my thought was more in like a 21-year-old range, possibly, is where I was kind of standing on that, just to where we thin it down, and at the same time, we don't take the entire swath of the populace in that. So I'll be a no on this with the intention of trying to just narrow it a little bit more.
Further discussion on the amendment? Question being called. All those in favor of the amendment to strike the 18-year-old requirement? Say aye. Aye. All those opposed to the amendment, say no. No. I think that failed. Further amendments, Representative Harold.
Thank you, Mr. Chairman. So I would just take another swath at this and strike out the under the age of 18 and insert under the age of 21.
Second by Oakley. Discussion on the amendment, Representative Haroldson. Anything?
I just think that there comes a point where people, I think that getting that extra 3 years in there can help a lot. And at the same time, doesn't open it up so much that we're having to try to appoint an attorney for all cases, because it is a may, not a shall, but may sometimes turns into shall, so we don't want that. So I think 21 would just be a good compromise where we still are narrowing that pool, but we can maybe grab the net a little wider on some of these other people.
Question being called. All those in favor of Representative Harrelson's amendment to raise it to 21, say aye. Aye. Those opposed, no. That amendment carries. Further amendments. Representative Craigo.
Okay, I'm gonna take one more stab at this. And I'm fine with the 21 if that's where we end up. But it still doesn't really get to, I guess, what I was trying to get to, because I'm not sure age is always the determining factor. So I'm just gonna roll out a proposed amendment, and we can, if we can get a second, we can chat about it and vote it up or down. And I would take out the first clause, strike the first clause, if the victim is under the age of 18, comma, and I would replace that with, if the court finds the victim is unable to represent himself or cannot afford an attorney, comma, the court may appoint an attorney to represent the victim in the action.
Second by Provenza. And now with that amendment, Representative Craigo, would that replace the previous amendment?
Yep.
Is that the plan? Supersede it?
Yes, it would supersede Representative Haroldson's amendment, but I'd like to ask Ms. Chambers maybe a question.
Ms. Chambers?
She's back there. Making faces, yes.
Good afternoon. Kara Chambers, Director of Division of Victim Services.
Representative Craigo.
So I guess the proposed amendment, although it does reference indigent, I'm using different language, but it also references unable to represent themselves, which I thought would catch the under the age of 18 argument that the judge was talking about. It would also capture the under 21, so it still does both. And we could use and that's probably what I should have put in there is unable to represent himself and cannot afford a private lawyer, which probably would have been better. And then that would have closed that loophole a little bit, because there are people who can't represent themselves but can afford a lawyer. Would that make more sense? And when you're back there shaking your head, explain what you were
Go ahead,
talking
Sharon.
about.
What do you think on that?
Chairman, Representative Craigo, what I was shaking my head is you were pretty much going back to existing law. And I have to tread very lightly because, I can't state an opinion per se. I'm here to provide information. But I would point out that, I believe your amendment as proposed is actually expanding more than existing law, which was, I believe, contrary to the intent of the court, which I'm fine with, but I mean, actually, I shouldn't even say that. I mean, I just wanted to point out that, we're going in a different direction than the draft, so.
Well, and then that becomes an issue of what's wrong with that. So
Right,
let's have a little discussion on that. Representative Provenza.
Thank you, Mr. Chairman. Ms. Chambers, could you maybe walk us through, because my concern with the last amendment was that 21, it's arbitrary. It's a number that we've decided means you're an adult. But I think that there's a lot of other factors that might make it more difficult for a victim to be able to represent themselves. I just think about, this is probably an extremely traumatic time in someone's life, and the brain fog that comes with that is pretty severe. So maybe if you have any direct experience, or you have any just information about what other factors might cause us to want to make sure that we are giving an attorney to a victim.
Go ahead.
Chairman, Representative Provenza, I'm going to answer this a little bit different than how you asked. So the existing law, of course, was intended to, I mean, there, we do have pro se orders. You don't need to be represented. In fact, we have just, we, and I do mean we, because I have the statutory responsibility to approve these forms for the judiciary. And we just released revised pro se forms on protection orders July 1. To try to make it more user-friendly, we went with some more plain language attempts and more direction. So that's some informational. So the existing law, the intent was that if someone truly wanted an attorney, it was complex, they felt that they needed help, income should not be a barrier to that. And that relates to some federal law out there with Victims of Crime Act legislation and whatnot, specific to certain types of victims, specifically sexual assault, stalking, domestic violence, et cetera. So that's where the origins of that kind of language came from. You are right. These situations are fraught. My office had previously been providing funding through that grant, Victims of Crime Act, to the courts via Equal Justice Wyoming to provide some money for these attorneys. The court has brought this to your attention because there's acknowledgement that there's never enough money and there are never enough attorneys to do this. The philosophical question that you're asking is that the right thing to do, to have this cadre of attorneys and have a mechanism to appoint this for these civil matters is, I believe, the intent was yes, that we do believe that's the right thing to do, but the policy decision on what that looks like and who we're covering and when we're providing for it. I will acknowledge that my office has had to cease that funding because it just simply wasn't enough, and there's a few other nuances behind that. And so I am sympathetic with the court when they're saying, look, I think the existing language sets up this expectation, because it does. And I do hear that from a lot of victims, that, well, it says but I can't find anyone to help. And that's where, my office is coming in with what we've already discussed, having these lay people, advocates, really, making sure that they're not practicing law without a license, but really trying to walk those victims through the pro se component and really being there for moral support. But moral support doesn't replace legal advice. And that's the conundrum. And I've not presented a solution for you, but hopefully given you a little bit more information of the daily reality that we're facing.
Representative Crago.
Thank you, Mr. Chairman. So by taking out the district attorney portion of the proposed language in the original draft, are we really accomplishing anything at all with what we're spending lots of time on this provision. Are we really helping you or the judges at all?
Chairman.
Ms. Chambers.
Representative Crago, if I followed correctly, where we are is if a victim is under the age of 21, the court may appoint an attorney to represent the victim in an action. I think that's helpful. I think in my opinion, it is narrowing the scope from everybody who's indigent, anyone who's asking kind of sort of situation. I think you've had good discussion. I don't really need to weigh in on that, but I think it doesn't hurt. I do think there's an acknowledgement that there's a special pool of victim that might need additional assistance. I will point out that the existing law already had a provision for if the petition is not filed by the district attorney, meaning there are occasions where the district attorney does come in. And remember, this statute, that when we're on page 2 and 3, we're under the stalking and sexual assault statutes. There's obviously mirror language and actually a little bit expanded language in the domestic violence, because it also talks about vulnerable adults. But I don't know if I answered your question. I think you guys are the ones who get to make those policy decisions, but.
Follow up, Mr. Chairman. So, yeah, we're just trying, I just don't want to make.
I understand.
I don't want to make it more complicated for you by trying to help. So, Mr. Chairman, at this point, I'm going to withdraw my motion. I'm still not super tickled with where we ended up, but I think for today, we have other stuff we can talk about. We can think about it between now and session and maybe work with Ms. Chambers and the judge and see if there's some sort of better language we can bring to back to the bodies in January.
Very good.
If my second will agree.
Motion's been withdrawn. Any further amendments proposed for this bill? Mr. Co-Chairman.
Mr. Chairman, I would move the language at the bottom of page 8 in the staff comment, nothing in this subsection shall prevent the victim from hiring an attorney or filing a petition pro se. I believe that would go in 3521-103E. Right at the bottom, I would move that.
By Representative Oakley. Everybody clear on the amendment? Any discussion on the amendment? Representative Provenza.
Thank you. So just clarification, so we're adding the lines 24 through 27, and then on page 9, we're also adding H.
Mr. Co-Chairman.
I didn't understand the question, but yes, that would go at the bottom of page 8. And if there's another spot on page 9, I didn't understand the question. I'm sorry.
You're fine, Mr. Chairman. So I'm just trying to make sure, are we adding also, so on page 9, lines 1 through 5, the court may require the respondent to pay costs and fees, or were you referring to something else?
I did not include that in my motion at this time. Yeah, thank you.
So we're adding that language on page 8, lines 24 through 26 in red, somewhere around line 15 on that same page. Is that correct?
That's correct.
You have the amendment down there, LSO, you got that? Are we good? Any further discussion on the amendment? All in favor of that amendment, say aye. Aye. Those opposed, no. That amendment carries. Any further amendments? Hearing none, let's have a roll call on 121.
Mr. Chairman, this is a roll call vote for 25 LSO 121, protection order amendments as amended. Senator Case? Aye. Senator Cooper?
Aye.
Senator Furphy?
Excuse.
Senator Schuler? Aye. Representative Chestick?
Aye.
Representative Crago? Aye. Representative Haroldson?
Aye.
Representative Jennings?
Excused.
Representative Nemec? Aye. Representative Oakley? Aye. Representative Provenza?
Aye.
Representative Rodriguez-Williams? Aye. Co-Chairman Landon?
Aye.
Chairman Washit?
Aye.
Mr. Chairman, we have 12 ayes, 2 excused.
Thank you very much. That takes us to Bill Draft 122. Ms. Adams, is that yours as well?
Yes, Mr. Chairman. So this is 25 LSO 122, Working Draft 0.5, Protection Orders Effective During Appeal or Review. And so if you'll recall at your last meeting, there was a request to ensure that protection orders remain effective during appeal. And so what this does is it specifies the applicability of stalking, sexual assault, and domestic violence protection orders during appeal or review. It's going to create parallel amendments in the stalking and sexual assault statutes in Title VII and also in the domestic violence protection order statutes. So starting on page 2, the stalking and sexual assault statutes are amended to include a provision which provides that an order of protection granted under 73506 through 73512 shall remain effective during the pendency of any appeal or review of the order of protection or any decision to modify or extend the order of protection unless a court orders a stay during the pendency of the appeal or review. And then there's a similar amendment to 3521-106. It just mentions that it's an order of protection granted under this act, meaning the Domestic Violence Protection Act. And then there's a staff comment that provides some background on appeal and review of protection orders. And then it also addresses the issue of stays and notes that if, just that the bill doesn't limit the authority of the courts to issue stays during the pendency of appeal or review. If the committee did want to do that, you could run into some separation of powers issues. And with that, I would stand for any questions.
Thank you, Ms. Adams. Any questions about the bill draft? Seeing none. Anyone in the room wishing to testify with regards to 122? Anybody on Zoom wishing to testify on 122? No one wishing to testify? I will close public comment. Committee, what's your pleasure? Moved by Representative Rodriguez-Williams. Is there a second? Second by Representative Craigo. Discussion or amendments? Have a roll call vote, please.
Mr. Chairman, this is a roll call vote for 25 LSO 122, protection orders effective during appeal or review. Senator Case? Senator Cooper? Senator Furphy? Senator Schuler? Representative Chestick? Representative Craigo? Representative Haroldson? Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza? Representative Rodriguez-Williams? Co-Chairman Landon? Chairman Washit? Mr. Chairman, we have 11 ayes, 3 excused.
So that brings us to the section, into the section on protection orders. Is there any public comment? Public comment with regards to protection orders?
Mr. Chairman, could someone please talk?
Welcome back.
Thank you, Mr. Chairman. I wasn't sure because there was a LSO memorandum on the permanent protection orders that got very well made into the weeds on other states. But after thinking about this, I think the easiest way to do a permanent protection order would be to look at anybody convicted of a violent felony. The victim would be entitled to a permanent protection order. That gets to the tolling issue. You wouldn't need the tolling issue anymore, or the tolling statute anymore, because that was our concern 6 years ago when Senator Landon brought this in discussion with Tara Muir. If I would have woke up at 2 in the morning and thought of it then, we might not have had this tolling statute, but it's not workable. And in fact, we just had one last week where an individual was informed by a parole officer that an individual is getting out of the penitentiary, came in panicked and refiled an application, did state in there, referred us to a judgment sentence where we've had the sheriff's office find out how much time they were serving in the penitentiary, and were able just to do an extension instead of going through a new protection order, which may not have been granted if there weren't any change of situation, or which would be required because there was already one issued. So it brings up the violent felonies includes sexual assaults, all strangulations, third offense, domestic batteries, and aggravated assaults on household members. The point of discussion would be, does that go to all victims of violent felonies? We've had individuals come asking for protection orders when they were victims of aggravated assaults, but not fit under the definition of household members. Attempted murders not fit under the definition of a household member. So that would be a point of discussion if you wanted to open it to all violent felons. And seems like there was a second point, but if the victim brings it, or is it automatic? Does the victim automatically get a protection or permanent protection order because you're a victim of someone who is convicted of a violent felony, or would the victim need to bring the application for the permanent protection order?
So if I'm clear, Judge, you're talking about that there has to be a conviction of the violent felony.
Yeah, and that's...
And it's a permanent protection order.
And that's what we deal with in tolling, Mr. Chairman. They're convicted already. So we're trying to figure out, and if it happened in another state, we may not get that information. If it happened in another county, it may not come to our attention. But if this would alleviate a victim from having to, some, I don't know how many percentage of our victims let a protection order lapse when the individual goes to the penitentiary. And that tolling statute was there to provide that potential to have that protection order after but after they get released from the penitentiary, there's no mechanism to let us know they've been released. There's no mechanism for the courts to know what is that time frame for that tolling period. We've explored different things with, it's just not something that's easily accessible. This would take care of that, but it would also give individuals, they could waive it, the victim wanted to waive it, that's fine too. But they wouldn't have to come back every 3 years to get a protection order when they were a victim of a violent felony.
Sounds like a workable solution. I see Director Shannon doing his best to hide behind a pillar back there. Would you come forward, sir, or maybe? Ms. Chambers, do you have some comments on this idea?
Chairman, I do. And not to contradict the judge, but he just said I could. No, I think that's excellent, but I would like to point the committee to some of the other states and how they do it, in particular Montana, where a judge may order a temporary order to remain in effect permanently. In making this decision, the judge may consider factors such as the subject's, quote, history of violence, the severity of the offense at issue, and the evidence presented at hearing. So it would be a little bit more than just the conviction of a violent felony, because what I would like to point out is we see this interesting duality happen. If you do have a victim of a very serious felony where they are sentenced and serving some substantial time, the need for a protection order is somewhat moot until perhaps they are out. But what we see more common are these frequent, repeat misdemeanor domestic violence situations that begin to escalate. And I think some other states even use language about a propensity to violate the orders, all these things that they take into consideration in a permanent protection order when you get to that point. And I would just encourage the committee to look at some of that language. The other thought that I had was just something that the judge did point out is we only have 3 types of protection orders: domestic violence, sexual assault, and stalking. And so if you're tying it to a conviction of a certain offense, you're going to have language that, narrows, or you're going to create a new protection order type. You could do that as well, I suppose. But those are some of my thoughts. I would argue, I'm not here to argue, I'm here to provide information, that, we're not alone in looking at this topic of a permanent protection order.
So Director Shannon, the reason I asked you up here, just a little perspective on the tolling of these things, and from your vantage point in the Department of Corrections, how much of a challenge is it to help keep track of all this?
Mr. Chairman, committee members, I'm Dan Chan with the Department of Corrections. It's really not a challenge to keep track of it. However, there's things that we just don't have control over. Judge Christensen testified that about the short notices that he receives. The Department of Corrections doesn't release people from the penitentiary. That comes from the Board of Parole. So when the paperwork comes to the parole, we may provide 6 weeks notice, we may provide 2 hours notice. It depends when that paperwork comes through from the Board of Parole releasing an individual. Ms. Chambers spoke of it may be a moot point when they're incarcerated, but I would respectively disagree with that, because unless they're a certified victim, I would ask that if we go that pathway, that it remains in. If they're not a certified victim, we have difficulties. You have individuals that are sentenced for a period of incarceration because of their violent behaviors, yet things change a year from now. Now these folks want to come in and visit these. So if we're going to do the protection order, and it's for certified victims, let's do it that way.
Okay, so we've got the topic before us. Committee, is there action we want to take? Representative Oakley?
Thank you, Mr. Chairman. Can I ask a question before I do that? I just wanted some clarification from Director Shen. I don't understand, I didn't understand your certified victim comment.
Director?
Yes. We'll go back and, I'm sorry, Mr. Chairman, Representative Oakley. We'll go back and we review the judgment and sentences to determine, by policy, we're forbidden to keep them out unless they're a certified victim. So we'll call the victims and encourage them. Now, if they're underage, I can resolve that. But you may have victims for domestic violence that 2 years from now they want to come visit. And I know recent reviews, I stopped the visits, but we no longer can stop it regarding like video conferencing visits and things of that nature because I can't demonstrate the safety aspect of it. But to me, emotionally, I think it does create more troubles for the victims.
Thank you, Mr. Chairman. I don't know if so how are you relating that to this, to the permanent protection order?
Judge, what I thought I heard Judge Christensen say, that they would have an opportunity if they want to revoke it and not have it. If they're incarcerated, if we're going to do it, they should have it while their perpetrator is incarcerated. Because what we're doing is, I believe, from my viewpoint, is we're re-victimizing these individuals. If we don't make it permanent while they're incarcerated, if that's the case, many times the victim is often, for whatever reason, will change their mind and want to come visit that person that assaulted them. And I certainly don't support that. Thank you.
So committee, is there a desire to do something with this topic, or is this just informational? Representative Oakley.
Thank you, Mr. Chairman, and I guess if you guys will stay there when I make this, if you give me maybe I'll withdraw or something. You can give me one of these. So I guess my motion would be to do a bill draft that I got from Judge Christensen's words, which would be fairly straightforward, that a victim of a violent felony that ended in conviction is entitled to a permanent protection order. And you can reference violent felony under 61104A, Romanet 12. And I know that doesn't hit what Director Chambers is talking about. Maybe if somebody else wants to bring one, I think that's it's just a different topic, or maybe not topic, but yeah. But maybe if we start here, we could work with that. But so that's the motion for a pretty straightforward bill draft. Does that seem good to everybody in the room?
Is there a
Judge?
second to the motion? We'll have discussion in a minute. Is there a second to the motion? Second by Craigo. So we have a motion for a bill draft dealing with, Brian, do you have a question?
Yeah, Mr. Chairman, and then my understanding is intended with that draft is that the current language in both the domestic violence and sexual assault protection orders concerning tolling would be stricken.
Oakley, you want to strike the tolling language as part of that motion?
I think there's a little more LSO comment coming before I'm ready to figure that out.
Mr. Chairman, so I think Director Chambers hit on something that's tricky about this. So the stalking and sexual assault protection orders, the way you get those is that they're linked to stalking and sexual assault, right? Not necessarily a violent felony. I'm not sure if those fit inside of that, but they're different types of protection orders. So I don't know if this would be an entirely different type of protection order for violent felonies. And then we would probably, what I'm thinking conceptually right now is there'd be a new set of statutes that address this type of protection order and make it permanent, and probably have to build in some of those things for the
So much for a
petition.
nice, tight bill draft.
Yeah.
But I, at least conceptually right now, I think it muddies the water to connect them, and this would be a standalone, a separate section. What?
Mr.
The permanent
Chairman,
protection order,
Is
yeah.
the second on the amendment still good with the amendment? All right, so we have a motion or not on the amendment, motion on the bill draft, create a new section of statute dealing with protection orders for violent felonies.
Permanent protection order.
All right, any discussion on this? Representative Shestak.
Thank you, Mr. Chairman. I'm in favor of a bill draft. I'm just, depends on how the bill draft comes out. We may have some further discussion in November. I do think it shouldn't be automatic. I think it ought to be, if discretionary for the court. If certain, like Montana, I think has some criterion on when you should do it, so it shouldn't be automatic, but we can deal with that. So I'd like to see the bill draft, and then maybe we'll have to deal with those conditions later.
Further discussion, Representative Oakley. We don't need to debate the bill draft at this point,
Yeah,
right?
thank you, Mr. Chairman, and I don't know if thought the judge maybe was going to weigh in. The verbiage that I gave was entitled to, means that you would have that sort of standing, if you will. It is not automatic.
Sensing an urge to vote, all in favor of the request for a bill draft, say aye. Aye. All opposed, say no. We will have a bill draft for November. Further discussion on protection orders. Further public comment on protection orders. Saying none, appreciate public comment. Close public comment. We're concluding section on protection orders. We need to move now to our Mental Health and Vulnerable Adult Task Force. I hope you're going to read the green books to us. So, Mr. Chairman Larson, would you like us to have the bill drafts presented by the LSO staff first, or you want to give us some introductory comments?
If you wouldn't mind, Mr. Chairman, I'd like to just give a couple of introductory comments to. Thank you, Mr. Chairman, and members of the committee. The Mental Health Task Force has been meeting throughout this interim to continue conversation on court diversion, vulnerable adults, adolescents with high behavioral needs, and mental health services in the K-12 model. We'd like to extend our appreciation again to this committee for helping us last year with House Bill 26 and House Bill 27. Just as a reminder, this task force is made up of representatives of the House and the Senate. Then we have Justice Fox, who is oftentimes represented by Ms. Butler. And then we have Director Shannon, Director Schmidt from the Department of Family Service, Director Shannon from Corrections, Director Johansson from Department of Health, and then Dustin Brown from the Department of Education, which is why we can't carry anything forward and we need to assistance from standing committees. For the committee's edification, I reached out to the chairman and on these two bills that you'll hear today, requesting that you would again consider them and perhaps present them in this next budget session. So with that, Mr. Chairman, Anna, who is one of our legal advisors here, can certainly walk us through the bills, and then we've got Director Schmidt and here to talk about the first bill on confidential information, and then Ms. Butler's here to help provide further information on the treatment court amendments. So we'll follow at your discretion.
Thank you. Brian, do you have 0004? Oh, you? Okay, very good.
Thank you, Mr. Chairman, members of the committee. My name is Anna Johnson, Legislative Service Office. This first bill draft is entitled 25 LSO 4, Department of Family Services Confidentiality Amendments. The bill draft was referred from the Mental Health and Vulnerable Adult Task Force, and the bill draft essentially allows DFS to share data within the agency as well as with other state agencies in order to help communities in the state to better understand areas of strength and need, improve care coordination for individuals receiving support from multiple programs, program outcomes, and to better evaluate how well programs perform. Right now, DFS is limited in its data sharing, which affects development of a federally required comprehensive child welfare information system, behavioral health reform, and the implementation of SNAP, child welfare, and Medicaid. So beginning on page 2, in Wyoming Statute 9-2104A10, notwithstanding any confidentiality requirement of the listed statutes, the Director of DFS shall review the effectiveness and impact of programs and services, which shall include the sharing of data to the extent permitted by federal law for the purpose of referrals, provision of services, and participation in research. On page 3, in Wyoming Statute 14.3.214A, 14.6.203, and 14.6.306, those are conforming amendments. 14.6.437 on page 4 indicates that notwithstanding subsection A of that section, DFS may share data in accordance with the first statute in the bill draft. 14.6.604 on page 4 is amended to show that information contained in the Juvenile Justice Information System shall be accessible to DFS for purposes of sharing data for referrals, provision of services, and participation in research. And then Wyoming Statute 2118-202A6C on page 5 indicates that DFS shall be included in a statewide longitudinal education data system that serves as a statewide exchange for management and analytical reporting in support of education and workforce outcomes. Changes made to Wyoming Statute 35-2108 and 42-111A on page 6 are conforming amendments. And then section 2 on page 7 is a rulemaking section. Section 3 is a reporting requirement where DFS is required to report to the Judiciary Committee on the types of data shared pursuant to the bill and any safeguards that have been implemented to protect personal data. And then section 4 is a split effective date, and I would stand for any questions.
Committee, any questions on the bill draft? Okay, seeing none. Director or Chairman Larson?
Mr. Chairman, just looking through my notes, I think it'd probably be best just let Director Schmidt take us through her comments, if that's okay.
So try to help us understand the whole goal here or purpose.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Department of Family Services. Nice to see you again so soon. This bill really is, it appears to be complicated, but it isn't. The current statutes around the Department of Family Services and the records that we receive, the reports we receive, are highly, highly protected under state statute. So when we receive a report on, for example, a child protection issue, a report, somebody calls us, gives us a name, that's considered a report. We cannot speak to anybody about that report. It is confidential, and for good reason. However, it is very limiting in terms of what we can do to share referrals, to understand more about the services, and also to do the long-term research about the outcomes of our program. So what this statute intends to do is to give the director the authority to be able to, through rule and then also through memorandums of understanding and other guidelines, to allow for information to be shared for very specific purposes. And to give you a few examples as to why that's so important. A lot of the work we do is in the prevention area. We receive calls about families, and we will take those calls in, and we will find that they do not meet the statutory requirement for abuse and neglect. But we also know that those families may need a little bit of help. At this time, what we do is we say, here's a few phone numbers, please call them if you want services. What we would like to do is to be able to say, public health nursing is something that might be really helpful to you right now in their nurse home visitation program. Can we call them, give them your name, and have them call you? The client can say yes, but the statute doesn't allow us to make that call. So that's an example of a referral of service that we think would be incredibly important and beneficial for a family, but yet we can't make that direct connection. Another example of why this is important is because of some of the work that this particular committee did a few years ago around the Juvenile Justice Information System. So you all decided that the Department of Family Services needed to receive the information from the Supreme Court and hold that information within our system. We do now have that system. We've executed the memorandum of information. The data is ready to come to us, and it will be coming to us as we continue to roll out our new case management system. However, none of that data can be connected to the other data that we have in regard to our juvenile delinquents, our juvenile probation, or our children in need of supervision. So while we can analyze what's in that particular data system, we cannot compare and contrast it to what we have in our other case management system called WyoSafe. So we will have the Juvenile Justice Information System in one place, WyoSafe in another place, but the two won't be able to talk. So that's an example of the research. Another place where this is really important is in information sharing with other agencies. And this morning, we spoke about the burden of reasonable efforts. And you were asking us about what that means. And I explained this morning what that means is connection to services for parents, for children when they need them. The behavioral health redesign really anticipates that the Department of Family Services families will be priority. However, as it's designed right now, we would not be able to call a community mental health center, give them a name of a client so that they could reach out and provide those services. So the behavioral health redesign then, in effect, is hampered by the limitations on our statute. So those are some concrete reasons as to why we think this is very important. The bill itself really just has a lot of conforming amendments in it. And the reason why it was approached that way is because the confidentiality provisions that are listed throughout are each written in very different ways that to wordsmith it, to make it consistent, would have created a very long bill. We tried it, it was very long and very complicated. And so this is why the decision was made to bring it to the authority of the agency director, with the guardrails around rules and regulations, policy, and memorandums of understanding with the entities with which we'll be sharing data.
Anything further? Chairman Larson.
Thank you, Mr. Chairman. And so I wanted to follow up on Director Schmidt's comments and just kind of share with you the conversation that we had during the task force committee meeting. Probably the most important one is most of us have been there, they're on that committee, been in the legislature for an extended period of time and understand the significance of confidentiality of personal information and why that needs to be protected. And the state of Wyoming, I believe, has done an excellent job of making sure that that information stays preserved. We continue to preserve that, but then recognizing that as we try to, one of the biggest challenges we've had with getting new information systems is to try and make sure that they'll talk to each other. But we've done that, they just can't share the information between one system to the next because of the statutes. We talk about, when Director Schmidt talked about Department of Family Services being able to make a reference to a community mental health center, we want to be able to do that before they're in crisis and before there's been an adjudication. And right now, we can't do that. And so we felt, after lengthy conversation, whether to do a bill that Director Schmidt referred to or put the language where we do in the Director of Department of Family Services statutes in Title IX, and then making reference to that to conform it to the rest seemed to be the simplest and most appropriate. But it was a fairly lengthy conversation, and just wanted to share that with you.
Question? Representative Oakley.
Thank you, Mr. Chairman. I just have no idea, but when I see the sleds mentioned, it seems like that's a costly thing. Is there a discussion on costs? The fiscal note, is that expected to be significant?
Chairman Larson, or Director.
Thank you, Mr. Chairman. Representative Oakley, this is just the original statutes that create sleds, and we are already participating in that effort. What we aren't able to do, though, is share the information with the educational data set because of these provisions. But I'm a member of the e-board, and we participate in the grant activities, and it's through that then that the funding supports all of these efforts.
Director or Chairman, do you see it as necessary for the committee to make a decision today whether or not to bring your bill, or is this a decision we could make in November?
Mr. Chairman, we're here because you've granted us the we're here to do what and comply with however you would like to approach this. And we're happy to provide additional information. If you decide to wait until the next meeting or the following meeting, we'll do whatever you want. We felt it's important to get in front of a standing committee and wanted to do so before your time ran out.
Very good. Senator Case.
Mr. Chairman, it was in our advance packet, and I guess it was on the website, but I don't know if people really had notice in a real big way. I expect this is going to be a pretty easy bill. Maybe we could adopt it as a committee draft and then have it available at our next meeting, and so plenty of public input.
Is that a motion?
Yes, as a committee draft, not a final roll call for our next meeting.
Committee draft and a second by Oakley. Discussion on that motion? Say none. All in favor of the motion, say aye. Aye. Those opposed, no. All right, so we've adopted that bill as a committee draft, and it'll be on the agenda for November.
And you got to come back.
And that meeting will be in Casper. Now we have 103. Very good.
I'd just like to inform the committee that you'll recall that we've got a pilot program going on in Campbell County for diversion for misdemeanors away from the court system if there's a mental illness involved. And as we've been watching and monitoring that pilot program unfold, I think a second program is being considered in Natrona County. I don't know if they've pulled the go plug on that yet or not, but this bill addressing the treatment court statutes is to help our existing statutes and what we contemplate with this diversion project to where they fit more holistically with each other, and are very pleased with the progress that the pilot program is making, and very pleased with the conversation we've had in working around this problem that we know has existed in our judiciary system for a long time. So with that, Mr. Chairman, perhaps we could ask Anna to walk us through this next bill. This is 103, isn't it? 104?
103.
103, thank you.
Please, go ahead.
Thank you, Mr. Chairman, members of the committee. This bill draft is entitled Treatment Court Amendments in its version 11. The staff comment on page 2 indicates that this bill draft combines this bill draft involves the diversion court amendments as well as a couple of amendments regarding the Public Defender Act and a couple of other things as well. Beginning on page 3, several treatment court definitions are amended. The definition of applicant was changed to include one or more governing bodies. Continuum of care was amended to include mental health treatment. Dual diagnosis was amended to say substance use instead of substance abuse. And participant was changed to include persons with mental illness or a dual diagnosis who have committed an offense, including those who have had law enforcement contact with or without arrest. Program was amended to include one or more local court supervised treatment or mental health programs, and then referring judge was amended to strike substance offenders and include participants. On page 5, substance abuse treatment was changed to substance use treatment, and then substance offender was changed to include a person arrested for, charged with, adjudicated for a substance-related offense. And then definitions of mental health treatment and mental illness were added. Then in Wyoming Statute 512-105, that statute was amended to include unmet mental health needs and mental health screenings. Under subsection B, the goals of the program were amended to include striving for recovery and mental wellness of participants, and to reduce the number of people with mental illness in jail, criminal court proceedings, and the state hospital. Wyoming Statute 512-106 was amended to change referring judge to referring judges. And then Wyoming Statute 512-107, beginning on page 7, was amended to have participants contribute to the cost of their program where advisable, meaning that not everybody would have to contribute to the cost of their programs. Wyoming Statute 512-109 was amended to remove substance offender and insert participant. And then B1, beginning on page 9, was amended to include mental health screening. B2 was amended to include mental health needs. And then subsection C on page 9 indicates that referral and participation in a program and consent to participate when required shall be governed by the rules adopted by the Supreme Court. Subsection C also indicates that prior to a participant's entry into a written agreement, the participant shall be informed that he may be subject to a longer term of probation. Language regarding consent is stricken from subsection D on page 10. And I actually spoke to Mr. Fuller about this subsection. The committee may wish to consider indicating that juveniles are the only group that would be required to participate without consenting. It might be worth putting some language in there, just making that very clear. A new subsection E on page 10 indicates that a program may accept participants from any other jurisdiction in the state. And then Wyoming Statute 512-110B on page 11 indicates that if a participant is participating post-adjudication, they may be subject to incarceration as a sanction. A conforming amendment was made to 512-111, and then 512-115A on page 12 was amended to strike substance abuse and insert substance use, and to show that participants may have to submit mental health history to the program team. Wyoming Statute 76104E on page 13 is created to show that the public defender is authorized to serve on court-supervised treatment program teams and may represent participants in those programs, including sanction and expulsion proceedings. Section 2 indicates that Wyoming Statute 512-109A and B4 are repealed, and that stricken language is in a staff comment starting on page 13. Section 3 is a rulemaking section. It also indicates that the Supreme Court should make any necessary requests to support court-supervised treatment programs in its biennial budget request. And then Section 4 contains an immediate effective date. And I would stand for any questions.
Thank you, Anna. Any questions? Mr. Co-Chairman.
Thank you, Mr. Chairman. Just real quickly, Anna, nice work on this. I want to go to page 8. I'm just a little confused by the language, and I'm not sure that I've ever seen that word in the statutes where in double ruminant I require participants to contribute financially to their own program where advisable. The word advisable, advised by who?
Mr. Chairman, Co-Chairman, so that would be up to the program team whether or not they would need to contribute to their program. I suppose you could put language in there to make it a little more clear, but maybe Ms. Butler would have some suggestions as well.
When required, or somebody's going to advise that this person can't pay, but this one can? Is that how that's going to work?
Ms. Butler?
Mr. Chairman, Mr. Co-Chairman, I think we are open, I believe, to any change that you think is advisable. However, the reason, the intent behind this is a lot of folks who live in the treatment court space have indicated that some studies show that participants, making them contribute to their treatment is not actually anything that helps the participant and sometimes acts as a barrier. However, there are treatment court programs and judges throughout the state who are tied to requiring some of the treatment court participants to really have some skin in the game. So this was an attempt to kind of bridge that gap. And quite frankly, if the language needs to be improved, I think we're open to that.
Mr. Chairman?
Thank you for that.
Chairman.
Thank you. And Chairman Landon, the conversation in the task force was to completely eliminate that ruminant, to just not require it all. Current statute requires them to participate. And so we contemplated, because of the data and the stuff that we've heard, that it really oftentimes has limited impact, but yet, on the other hand, there are times that it may be advisable. And so that's why we added kind of now whether advisable is the right word or not, but the intent is to have some flexibility there for the people that are advising there to require it or to forego it.
Further questions? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Anybody can answer this one, I guess. On page 13, there's a staff comment that says the task force may wish to consider including an appropriation to the court supervised treatment program account. Was that intended for the committee or the task force, or?
Mr. Chairman, Representative Rodriguez-Williams, I forgot to take that one out. We took care of that in section 2. I apologize.
Representative Harrelson.
Thank you, Mr. Chairman. So on page 13, line 4 through 8, the public defender shall be authorized to serve on court supervised treatment program teams. What does the public defender think of that? I mean, I understand that could create that's a full-time job, or potentially I view that as like another full-time job. So just wanting to kind of hear hard on that. Okay.
Mr. Chairman, Representative Harrelson, this was actually a request from the Public Defender's Office. And the reasoning behind it is that they're covered by malpractice insurance for their attorneys, and they do participate in treatment court programs. But they were concerned because there was no clear authority in statute to allow them to participate, that their malpractice insurance wouldn't cover them in those circumstances. So we have, been in regular communication about this change with the Public Defender's Office, and it was at their request.
Further questions? Representative Craigo.
Thank you, Mr. Chairman, and this also could be for anybody, most likely the chairman, but I was just curious about the change in terminology from substance abuse to substance use, and how we're defining that. And then, for example, on page 9, we're still talking about a substance abuse assessment, not a substance use assessment. And so maybe you could just help us understand the language change there and how those two differing terms work together, for example, on page 9.
So the change of change of the word from substance abuse to substance use, and to actually make it more complete, would probably be a substance use disorder. We've kind of done away from the term substance abuse. It still lingers, and so a lot of the new language in here is just bringing statutes up to terminology that's currently used in the profession. If you could, Representative Craigo, point out where we missed the substance use and abuse on page 9, that would help me.
It's line 2, Mr. Chairman.
So I think that's a worthy consideration for an amendment. And there's another.
And Mr. Chairman, Representative Craigo, so substance abuse assessment, that term's used throughout statute, and there's actually a definition of it elsewhere. So I was a little hesitant to change it. But I suppose that we could make conforming amendments throughout statute if you'd want to, but it's just that there's another definition of substance abuse assessment in a different title.
But on line 8 of that same page, talk about the.
And that one could be changed. It could be substance use.
Okay. Representative Oakley, or follow-up?
Thank you, Mr. Chairman. Just for discussion, I know that certainly in today's world, like ever changing, this is the word we use now, this is, and I, rail against it, I guess, but I will say, this is the first I've heard of a switch to just saying substance use. I get it. But substance abuse is still predominantly used, and it is a substance abuse evaluation, and it is used throughout statute. I mean, I'm just kind of just throwing it out there for discussion that it's not necessarily just insignificant, and it's not necessarily just, oh, that's gone now, and we just say substance use. Maybe it's going that way, but it certainly is not prevalent yet.
Representative Provenza.
Thank you, Mr. Chairman, and anybody here can correct me, but in the field of having to treat substance use, use is a little bit easier to identify, whereas abuse, you can determine what is that. We're trying to capture as many people as we can on the early end, whereas if we say you have to be you're a substance abuser, does that meet a different threshold? What mechanism are we using to identify that? So as we're trying to grab people earlier on, when it's easier to treat them, substance use is preferred rather than substance abuse.
Representative Craigle.
Thank you, Mr. Chairman, and I guess that kind of gets to my follow-up, which was going to be, what is the difference? I mean, what's the definition? And to Representative Provenza's point, and I'm not sure it matters one way or the other, I just want it so that we don't create confusion within our proposed statute. That's all I was trying to get at with my question, I guess.
Chairman Larson.
Thank you. And as you know, it takes a while to get all of this done in statutes, and we've actually started that about 6 years ago when we changed the statutes for the state hospital and the Life Resource Center. We started using that. Probably was the first time we started using the change from substance abuse to substance use disorder. So I don't argue that in the world that most of you live in is probably still referred to most times as substance abuse, but I certainly have some, but I think that's the evolution of the definition, Mr. Chairman, that we're seeing taking place.
Okay, very good. Further questions on the panel about the draft? Senator Case, you want to make your favorite motion?
Can we just kick the can down the road a little bit?
Adopted as our draft. Is there a second? So we have a motion and a second to adopt this bill as a judiciary draft for further discussion in November. This is not to adopt the bill, but simply to make it a draft of this committee for further discussion in November. Everybody good on the Representative Craigle?
Can I just make one request of Anna, I guess, and just to make sure that we're not creating any issues with those differing terms within the bill draft, and maybe just report back to the committee that that won't create any issues, and if it will, help us come up with a solution to fix that.
Representative Larson.
Mr. Chairman, I failed and I apologize, but on page 2 of that, you'll see a staff comment that refers another bill 25 LSO 0029, which is entirely included in this bill. I think that bill may have gone out and I don't know if you did or did not receive it, but if you did, that's the reason we made this comment, just pitch that one because it's all in here. So if you see that someplace in your.
Yeah, if you just make sure we have the finalized version for our discussion in November. All in favor of the motion, say aye. Aye. Those opposed, no. All right, this bill draft will go on the agenda for November. Thank you all. Appreciate you being here and all your hard work over the interim on this important topic.
Mr. Chairman, just because we adopted these two kids, they still belong to you, Mr. Chairman.
We just want to be part of the family.
Thank you, Representative.
All right, which brings us to our committee directives. And someone reminded me that when we talked about peace officer training, there had been some preliminary comment about was there going to be any bill draft over any of that. You know, we spent quite a bit of time talking about peace officer training. And I would offer a motion with the committee's agreement that we have a bill draft to eliminate that 1-year grace period for peace officer certification. I wouldn't make that motion for detention officer basic, because those deputies work with partners all the time, where what's occurring in some of our jurisdictions, is peace officers are hired, given minimal types of training, and then allowed to work solo on patrol for up to a year before they complete their peace officer basic training. And so I don't think that in the 21st century we ought to continue with that approach. I did talk to the Chiefs and Sheriffs Association, and they were reasonably agreeable to the approach as long as it was restricted just to peace officers and not to detention officers. So if I could have a second, I'd appreciate the second from Representative Rodriguez-Williams. Discussion? Representative Provenza.
Thank you, Mr. Chairman. So just clarification that it would remove the 1-year grace period for patrol.
Peace officers.
Okay.
Peace officers, not detention, peace officers.
Thank you.
Representative Craigo.
Thank you, Mr. Chairman. Are you replacing that with a shorter time frame or no time frame at all that you'd have to complete
No time,
basic?
that you could not work as a peace officer until you were certified. So if a department could apply, take one of those officers and have them work in a clerical role or a community service, a non-sworn role within the department where they could receive some training and so forth. But they would not be certified as peace officers where they would have arrest authority until after they were credentialed.
So just a question with regard to shortages in peace officers out across our state and in particularly in the smaller communities. What's the effect of that, boots on the ground? What did the sheriffs and chiefs respond?
Their sense was that the vast majority of departments already do it this way, and that the ones that aren't are really the anomaly, that most departments recognize that putting a undertrained officer on the street is a big risk for themselves and for the officer's safety and their other officers. So we can debate it more fully during the November meeting if you agree to the bill draft.
Fair enough.
Okay, all those in favor of the bill draft request, say aye.
Aye.
Those opposed, no. Okay. Anything further?
Mr. Chairman?
Yes.
My apologies. I just learned there was someone online for public comment for the last 2 bill drafts.
Oh, very good. That's right. I did hear that. Please bring her in.
Yep,
My
Mr.
apologies.
Chairman, we have Andy Somerville online.
Ms. Somerville? Good afternoon. So if it's any help, we've adopted these 2 bill drafts for committee bill drafts, and we will have a full discussion and debate on these bills in November. But if you have information you'd like to share with us today, feel free. Otherwise, we'll take further comment in November. But it's up to you. Thanks for joining us.
Absolutely, Mr. Chairman. No worries. I would just share with the committee, I did hear the conversation about substance use disorder versus substance abuse, and I remiss to point out that my organization is still the Wyoming Association of Substance Abuse Centers. And so that's definitely a change in progress and something that we're not too terribly worried about. Mr. Chairman, for the committee, the only things that I would point out, I think that we can work on in November there were 2 issues. One of them you've already talked about, which is the cost where advisable and how that integrates with behavioral health redesign for those that are there for mental health concerns. And the second is on page 3 under participant. The last line, or that line says a person with a mental illness or dual diagnosis who's committed or is alleged to have committed an offense, blah, 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 with or without arrest. The concern is, from my centers, is what does that look like for mental health clients? If there's not an arrest and there's not a charge, there's definitely some hesitation and discussion about are we criminalizing having a mental health disorder? So, Mr. Chairman, I'll leave that conversation there. I think we could probably get some more clarity on that, and we can come back in November and talk about that.
Thank you for paying attention to these bills. We always appreciate this type of input so that we get it right. And very much thank you, and look forward to seeing you in November in Casper.
Thank you.
Very good. Thank you for that reminder. Apologize again for missing that public comment. Brian, you want to walk us through the damage we did, or the good work that we did this week?
So Mr. Chairman, just running through the last 2 days, the committee continued 25 LSO 131, which was the use of fraudulent documents to gain possession of property, and 25 LSO 0002 concerning the removal of an unauthorized occupant, and appointed a working group of Representatives Oakley, Provenza, Crago, Nemec, the two chairmen participating, Senator Anderson and other stakeholders. The committee voted to sponsor 25 LSO 128, the state's right of appeal in criminal cases. The committee voted to sponsor 25 LSO 123, the disclosure of sensitive information concerning the Office of Homeland Security. The committee continued consideration of 25 LSO 124, restoration of right amendments. The committee voted to sponsor 25 LSO 129 concerning settlement authorization for minors. And then, Mr. Chairman, for this one, I would welcome maybe more direction. 25 LSO 130, governmental claims, maximum liability amounts. There was a motion to table that. Mr. Chairman, given the considerable public interest, who may want, be interested in seeing that come off the table in November, maybe more direction for that group may be helpful going into that third meeting.
Mr. Co-Chairman, that was your motion to table. You want to?
So, Brian, are you suggesting that the committee might want to consider untabling that bill and taking a different motion to forward to the November meeting? Is that what I'm understanding? I'm sorry.
So, Mr. Chairman, given some of the comments by the committee, that sounded like the committee voted to table this and would only consider it at the third meeting if it was brought off, if there was a motion to bring it off the table. Given the public interest, the folks who may want to show up and testify to that, on that bill draft, further direction on, whether the committee will or will not look at that draft may be helpful.
So let's just get a straw poll. How many members would vote to bring that Claims Act bill draft off the table in November? Just a show of hands. I think we have a majority, so I think we could title it as likely to be discussed. How about that?
Okay, and Mr. Chairman, we'll prepare the agenda accordingly for that.
Thank you, Brian.
Yep. So, Mr. Chairman, moving on, the committee voted to sponsor 25 LSO 218 as a committee bill, municipal courts, maximum penalties. The committee requested a new bill draft for the Governmental Claims Act to make clear that peace officers are not liable for negligent investigations. The committee requested a memo concerning what other states do for termination in light of certain violent or sexually related offenses. And I'll also include information based on Representative Haraldson's questions as well for the committee. The committee voted to sponsor 25 LSO 121, protection order amendments, 25 LSO 122, protection orders, the pendency during appeal. The committee requested a bill draft to provide for permanent protection orders. The committee voted to take on as committee bills for consideration of the third meeting, 25 LSO 4, Department of Family Services confidentiality, and 25 LSO 103, treatment court amendments. And then the committee voted for a new bill draft to remove the one-year grace period for peace officer training and certification.
Good couple days' work. Representative Haraldson.
Thank you, Mr. Chairman. Just a clarification on the 25 LSO 0124, the restoration of rights. Just for a clarifier, just to make sure that I understand correctly. We are going to be having a discussion of basically how to eliminate the firearm restoration rights for federal level as well as other states. Because at the end of the day, only Wyoming felonies can we address. Am I getting that correct?
Mr. Chairman, Representative Haraldson, my understanding was that there would be an updated bill draft that incorporated either in the bill itself or staff comment that language for the committee to consider.
And I just wanted to make sure it was other states as well, because we can't from everything I've done research on, we can't legally restore another state's rights. And if not, we're going to get a flood of people just coming to get their rights restored in Wyoming.
Right, so we'll get a staff comment for sure on as best we can determine the legal standing on that. And then, of course, this committee can make that read however we wish. Representative Provenza.
Thank you, Mr. Chairman. I just want to make sure that staff comment does include some discussion about whether we can restore gun rights if someone moves here from another state. I understand maybe some of the committee doesn't want to take that on, but I would like, if we can, because one of the concerns I have is someone moves here, they want to hunt, and they should be able to hunt. I would like them to be able to hunt. Are we going to say, you've lived here, now you just can't? That might be your prerogative, Representative Harrelson, but this is a committee, so I would ask if we could have just that staff
Yeah,
comment.
we can have that staff comment, then we can tease it out however we want in November. Anything further for the good of the order? Thank you all for your hard work, and we'll spend our last meeting together as the 67th session of Joint Judiciary Committee in 2 days in Casper. And maybe the co-chairman and I will host a little something for everybody when you're in town, so.
It'll be fun.
And with that, thank you, staff, for your work. All four of you, thank you. Do appreciate that. Drive safely, and we'll see everybody soon.
Now, that's the danger.